Okay, for those that have been able to log on, we'll go ahead and start. Um, there's still some confusion over needing a passcode to get in. Thank you, the three of you that saved the passcode and knew what it was. It did not show up in the last email, so people are probably having difficulty finding us. But Zoom now requires a passcode for all these sessions, so it will always be the same one. So hold on to it so you can get into us. We're going to continue on through the sales contract. I'm going to start again with paragraph 33. We may have covered it, but I'm not sure. So I'm going to start with paragraph 33 of the sales contract, page 11 of 13 of your contract. If everybody has found me, it's called void contract. If this contract becomes void and of no further force and effect without default by either party, both parties will immediately execute a release directing that the deposit be refunded in full to buyer according to the terms of the deposit paragraph. So what could cause a contract to become void? Well, if you do not settle by midnight on the day that you were supposed to settle as a buyer, then your contract is void and of no further force and effect, whether there's a release signed or not. But you would then be with default instead of without. So you're not going to get your money back unless you have a real nice seller that will agree to that. So when they're talking about without default by either party, some other things that could cause a contract to become void: the POA and condo documents, right? Home inspection contingency, finance contingency, appraisal contingency. All these can cause a contract to become void. Now, next Monday, and I hope everybody remembered this past Monday that I was not going to be there. I had to teach for the board all day. But next Monday at 11, I will be discussing the conventional appraisal form and the new appraisal contingency notice form. So I would like for you guys to join in on Monday at 11 to discuss that, because the conventional financing addendum, if the appraisal comes in low, your purchaser is going to have to void their contract if you can't agree, but with in the negotiating period. But under VA and FHA, the purchaser has the absolute right to void the contract if the appraisal comes in low, whether the seller is willing to lower the price or not. So we'll discuss all that on next Monday. But if the contract is going to become void, no further force and effect without default by either party, then the buyer has to do this correctly, okay? When I say do this correctly, if you go to page 38 of your package, if you've got this package for 2020, it is called notice voiding the contract. So anytime in this contract that it calls for your purchaser to have the right to void the contract by sending a notice, you need to send this notice voiding contract, okay? And then it says if you do that, then both parties will immediately execute a release directing the deposit be refunded. So if you go to page 15 of your package, that is the release of the sales contract in deposit. So you need to void first and then release. So if the contract calls for you to void, okay, then if you just send the release instead of the notice voiding, your purchaser probably not out of this contract. So they're talking, when they're talking here to void, you can send the notice to void, and then you can attach to that notice the release, okay? or if all parties just agree that the contract, they don't want to go forward. You know, both parties could release the contract without a voiding, but make sure that if the contract does call for a notice to void, you void first, like POA and condo, okay? Don't just try to release, all right? Any questions about paragraph 33? You can unmute yourself if you have a question, okay? All right, I hope to get through this whole rest of this whole basic contract. For those that haven't been with us through this whole journey, these are recorded. You can go back to our YouTube channel and review it. I'll start over again sometime in the future, but after we finish the basic contract, we're going to go through contract forms, addendum forms, and then we're going to hit into the listing agreement, do the same thing with the listing agreement, work our way straight through it, okay? So we have here home warranty, paragraph 34. I think this one's pretty self-explanatory. Will there be a home warranty, yes or no? If so, who will select the policy? Well, if I'm a buyer, I'm going to want to select my own policy. And who's going to pay for it? So I'm buyer, I'm going to want to select it. Seller, I want you to pay for it. You need to know the cost of these different programs and what they will cover, a cost not to exceed X amount of dollars, and who the warranty provider will be. I encourage you to start, if you've never had to get a home warranty, and start researching to find out who has the best policies and price, and talk to other agents in your office to find out who they've been using. Okay. Paragraph 35. This is one of the most important paragraphs in our contract. It is called time is of the essence. And that means that the dates and time frames agreed to by the parties must be met. These are not suggested dates. These are not suggested times. They have to be met. If they are not met, then somebody's either in breach or default. So you remember paragraph 28 says, if your buyer fails to settle for any reason other than a default by the seller, then they're in default. So come midnight on the day you put for settlement, if your buyer hasn't settled for any reason, unless it was the seller's default, then their contract no longer exists, okay? That contract is void by law, and you can try to get a release, but good luck, okay? So unlike Virginia Association of Realtor contract, it doesn't cover the language. I mean, cover this. So if time of the essence is not spelled out in your contract, in Virginia, what does that mean? Well, we'll get there. You know, sometime or another we'll make it. Just cool your heels and you know, let's see if we can get it worked out. So I teach in Charlottesville a lot, and in Charlottesville they use the VAR contract, and they say it happens. You know, we understand things can happen. We'll get there. Not that way in Northern Virginia. All right. Failure to meet stated dates or timeframes will result in waiver of contractual rights or will be a default under the terms of the contract. So as a seller, if you do not settle by midnight on the day of settlement, I can declare a default, and we'll go by paragraph 26 and 28, okay? However, let's say that you were supposed to settle today, buyer, and you don't, and you ask the seller to give you a 3-day extension, and the seller says, no, I won't give you a 3-day extension. I'm sorry. Enough's enough. However, if you can get to the table, call me. If you get your loan straightened out, call me. I'll still sell you my house, okay? But I'm putting my house back on the market immediately, which they have the right to do because your contract no longer exists, right? 3 days later, you call me and say, okay, we can make settlement now. I say, okay, I'll meet you there. So we settle, right? And 3 months later, your buyer wants to sue me for some reason, something to do with the contract. And I say, why? Because of this. I said, because it's in the contract. Yes, but since they didn't settle and I didn't give you an extension, they waived all their contractual rights. They waived all their contractual rights. Okay. So I may not be willing to give you the extension, but I'm still willing to settle on the house. They need to get legal advice about this. Okay. I'm just explaining to you what your contract says. So if somebody's not going to settle, okay, or want to know if they should sign the extension, I'd have them talk to their attorney. If this contract is contingent on financing and the contingency has not been removed or satisfied, any delay of the settlement date necessary to comply with the buyer-lender's obligations pursuant to the RESPA-TILA Integrated Disclosure Rule, okay, is not a default by the buyer, but seller may declare the contract void in writing. Wow, what does all that say? Well, this contract used to say necessary to comply with buyer-lender's obligations. So if if you weren't ready to go to settlement, all you had to do is get your lender to say, oh, there's still some obligations I need to take care of. I need to recheck this, redo that. But actually, I was the one that complained to the board about the language in the contract. That just would leave my seller hanging out there forever. So, and that wasn't the intent. The intent was if it's for RESPA-TILA. So what does that mean in simple English? Here's the three things I know that would kick in the extension, and it would be for 3 days, okay? If the interest rate went up by more than 1/8 of 1% over the loan estimate, which the lender has to give you within 3 days of loan application, and the CD, the closing disclosure, which has to be provided to you 3 days prior to settlement buyer, if there's more than 1/8 of a percent rate increase in your interest rate, then that requires a new 3-day disclosure. And since the CD didn't come to you until 3 days before settlement, then you need 3 more days because of RESPA-TILA. Then you could ask the seller for those 3 more days. Another instance would be if there was no prepayment penalty in your loan estimate, but now in the CD, okay, the closing disclosure, there has been a prepayment penalty added. Requires a new 3-day disclosure. Or the company that was underwriting this mortgage can no longer underwrite it and they have to substitute somebody in their place. That requires a 3-day written notice, okay, a new CD. Those are the only 3 that I know that would give you the right to ask for the extension. Not that the lender's not ready, okay, not that the lender's not ready. And it goes on to say, even if it is RESPA-TILA Integrated Disclosure Rule, even though it's not a default by the buyer, the seller may declare the contract void in writing. They may say, I'm not giving you the 3 more days. I don't care what the reason is. And they can declare the contract void. But if they declare the contract void, they don't get the deposit. There is no default. It would then have to go back to paragraph 33, where everybody agrees to sign the releases. Why would a seller do that? Well, they may have a backup contract, or the market may have increased so much in the 30 days that they're willing to start over with a new buyer at a higher price. Okay. Now, with the TILA Integrated Disclosure stuff, give your buyer enough time to settle. I've discussed this before, but the timeline, if you did a strict timeline, the purchaser can't make loan application until there is a contract under paragraph 2D of the contract in TILA RESPA. So within 3 days after that, the lender has to have into the mail a loan estimate to the purchaser. The only fee they could receive at that time would be a credit check fee and no other fee. That would allow your purchaser to go to more than one lender and make application, and the only thing they have invested is a credit check fee. All three of those lenders have to have in the mail to the purchaser within 3 days the loan estimate, and a day is any day their office is open to do all their business. Okay, so we'll keep it simple. We'll make it they did this on a Monday, so it has to be in the mail by Thursday. So we're 4 days into this. And so let's give 2 days for the mail to get there. We're 6 days into this. Your purchaser has 10 days to give intent to proceed on whichever one of those loans they applied for they want to go forward with. So if they took the 10 days, now we're 16 days into this. Now the lender can now get the appraisal fees, any other fees that they need in paperwork from the purchaser. Okay. And if you put 30-day settlement, they can't even order the appraisal yet. So make sure you give time. The timeline that I outlined for us when Tyler Respa first came out was 45 days. Okay. Now that's not saying you can't speed this up. If your purchaser gets together with the lender before they even start out and give them permission to do everything, they can have everything in line. They can take the loan application when you get the contract. They can give the loan estimate to the person right there, and if the person wants to sign it, you can really speed it up. But if that's not happening, don't expect the seller to automatically give you more time because you need it. Okay, because you need it, because the lender's not ready. All right, and a lot of agents get upset because when they ask for the additional 3 or 4 days, something comes back from the listing agent saying, we'll give you the 3 or 4 days. However, we want you to increase the earnest money deposit to this amount. We want you to give a credit to the seller of X amount of dollars per day, or just a cash amount. And the buyer agents get upset, and I don't understand why. The seller is the one adversely affected. They still have a house payment to make. Their stuff's already on a truck. They have to be out of the house. So don't be, so that goes on to say here, nothing herein under paragraph 35 shall prohibit the parties from mutually agreeing in writing to extend the settlement date under terms acceptable by both parties. Okay. I mean, your buyer agreed to it in a contract. Okay. They should know that if we need an extension of the settlement date, but you can pretty much expect this to come back, for your buyer to be paying some extra money here. All right. Any questions about paragraph 35? Time is of the essence. Okay. Because time is the essence controls all the paragraphs of this contract. Great. Let's talk about arbitration. Okay. Nothing in this contract shall preclude arbitration under the Code of Ethics and Standards of Practice of the National Association of Realtors. Arbitration deals only with money, okay? And the parties that can arbitrate, broker to broker, okay? So if you think you're entitled to a commission from a transaction was written, you as an agent, you do not have the right to ask for a mandatory arbitration. You can file for an arbitration, but then it goes back to your broker because it's not your money till it comes into the firm. It's the broker's money. So broker to broker. But the other one that people aren't aware of is broker and client. So if all parties will agree to an arbitration rather than going to court, it's a mandatory arbitration if your client asks for an arbitration against the broker. Okay. So this is where everybody's agreeing to it. A buyer and seller agreed to an arbitration if necessary. I've never seen it happen, but it's on the books. It could happen. Okay. Paragraph 37, real estate licensed parties. the parties acknowledge that whoever is disclosing here is an active or inactive licensed real estate agent in Virginia, active or inactive. So even, and when you have a license, you are, okay, you are still licensed, even if it's in Richmond on ice, okay? As a real estate agent in Virginia and or other, I would disclose no matter where I'm licensed, all right? It is either the buyer or seller or is related to one of the parties in this transaction. If you're the buyer and seller, you definitely can't forget to disclose in a contract that you are a licensee. Now, if you're a buyer's agent and you're representing one of the parties in the transaction as an agent, I don't think it's that drastic that this wasn't checked, but make sure you do check that you are related to the party in the transaction. This actually goes back to the days where we all represented the seller, and it was only, and so if you were a buyer or the buyer was your family member, everybody knew you really would be representing them, even if you were a sub-agent. So just get in the habit of doing this. And remember, there can't be a blank empty. So if paragraph 37, nobody's a licensed party, just put NA in the blanks. Don't leave anything blank in your contract. Okay. Paragraph 38, the entire agreement. This contract will be binding upon the parties and each of their respective heirs, executors, administrators, successors, and permitted assigns. What does all that mean? If there's a contract and the party dies, I am the administrator for my father's estate. We weren't under contract at the time, but if we were under contract, okay, then as administrator, I would have to honor that contract. So might not be in the best interest of the estate, but I would still have to honor that contract unless all parties would agree to release the contract, okay? So buyer or seller, you guys are, now, as an administrator, it's already been 2 years. I'm just about getting ready to wrap up the estate after 2 years. But would all parties want to wait that long? So realistically, if there's a death, most people will sign a release unless it's a really good deal. Okay, now this sentence I have come back to many times in past sessions. The provisions not satisfied at settlement will survive the delivery of the deed and will not be merged herein. In the old contracts, if something wasn't completed by settlement and I settled, it was over. Now, if there was something the buyer didn't fix that they were supposed to fix, and you can't let your buyer say, well, I'm not settling, I want my money back because they didn't fix the leaky faucet. Doesn't work that way, okay? So unless the default by the seller is so material to the heart of the contract that it would render it unenforceable, you need to settle, okay? However, what they didn't satisfy under the contract survives, so you have the right to go back and sue them afterwards. This contract, unless amended, is the final and entire agreement of the parties, and the parties will not be bound by any terms, conditions, oral statements, warranties, or representations not herein contained. It doesn't matter what we say. If we don't reduce it to a written addendum, it does not exist. You know, I hear that all the time when people come in and say, well, what is the buyer wants us to do this or do that? And I said, well, show it to me in writing. Okay. Well, they said they would do it. Well, then guess who's going to end up paying for it? Probably you. Okay. Has to be in writing. Okay. Now, not saying an oral contract is not valid. Okay, as long as everybody does what they said they were going to, it's valid. And if we settle, that's great. But if it's not in writing, statute of fraud says not enforceable. The interpretation of this contract will be governed by the laws of the Commonwealth of Virginia. Remember, our laws are different than laws in most other states because we are a Commonwealth. So don't start thinking Maryland for your interpretation of this contract in Virginia. Part of the reason that we did away with the regional sales contract in Northern Virginia is that there were a lot of stuff in that regional contract for DC and Maryland that needed to be in there that just had nothing to do with Virginia. So that's why this contract says Virginia on it. So don't try to use this in Maryland or DC. Will not work. Any questions? Guys, quiet today. Good. Paragraph 39, additions. The following forms, if ratified and attached, are made part of this contract. This is not all inclusive of addenda that may be attached. So just a little technical point here. If you're drafting a contract up, okay, and something is scratched out of the contract prior to ratification, okay, your buyer crossed it out when they were writing. It's nice to have an initial to show that they pulled it out, but the fact that it wasn't initialed by the other side is not a change to the contract. So if there was an initial missing for something that your buyer originally crossed out before they even sent it to the seller, you probably still have a contract, okay? I mean, we can't practice law, but nothing was changed. It's not a counter if it's never been signed by the seller and something else crossed out after the seller. So in other words, it got to the seller, they don't like something, they cross it out. Now it's a counter, but it's not a counter if it's done before you even send it over to the seller. Okay. But you need to have any addendum that's going to be part of this contract. Okay, it has to be ratified and attached. So make sure you check the box here that it is attached, because if the addendum came over, no note of it, and it wasn't signed, somebody might try to claim we have a contract without that addendum, right? So home inspection radon, yes or no? And if it's not being used, check no. Don't just check the ones that are yes, okay? Lead-based paint we've talked about. We will be talking about contingencies and clauses addendums. One, to make sure you remember there until we look at the form. If you're writing a contract as is on a property, you need to use the contingencies and clauses addendum, listing brokers especially, to remove all those other clauses that say otherwise contained herein's, because they may still be in the contract, okay? Pre-settlement occupancy, residential property disclosure, conventional financing, extension of review period for condominium resale certificate. You remember what that is? The law changed this year, July 1st, to say if the buyer and seller agree with a written addendum, the time period for the review of the condo and POA package can be extended up to a maximum of additional 4 days. So if the documents were hand delivered, it'd be 7 days to review. If they're mailed, it would be 10 days from the postmark. Seller does not have to agree to that. Generally, it would probably be an addendum sent after you get the package and the buyers realize how big that package can be, and they actually want to read through it, and they say, man, I need more time. At that point, you can send that addendum over, requesting the extension, but the seller does not have to agree to it. Does not have to agree to it. Private well and septic, we will take a look at that one in a later session, post-settlement. So pre-settlement, post-settlement. To me, kiss of death. Worst thing could ever happen in a contract. More problems arise from pre and post-settlement than anything else. Lead-based paint, VA, FHA, USDA financing. And the reason they separate those out from conventional, different rules, especially for voiding a contract or the appraisal rules. Okay. So whatever addendum you're using might be other. You might just have an addendum for some other thing that you want included in the property or not. So it could just be a blank addendum. Any questions about those? And we'll look at all these forms eventually. Great. We're almost through the sales contract then. Page 40, disclosure of sales price to appraiser. Listing broker and selling broker are hereby authorized to release the sales price listed in the price and specified financing paragraph to any appraiser who contacts them to obtain the information. The reason this is here, an appraiser can only use knowns, and a known is a property that has settled. And agents have a tendency to use the last sales price in a neighborhood, okay? That may not be the one that the appraiser has to use in accordance with Fannie Mae and Freddie Mac guidelines. But if we can show more than a 3% increase in a 6-month period, then the appraiser might be able to bump it up. So they might be looking for help. They may be looking for a reason to adjust this up a little bit rather than killing the transaction because it won't appraise. So share the information with them. It'd be the flip of that if the market is reversing more than a 3% loss over a 6-month period. That's what we call a changing market. So the appraiser needs that information to help us. Okay. Other terms, whatever you want to put in there for any instance that comes up. I, once again, please encourage you to check NVAR forms for addendum forms for other stuff, VAR library for forms for others, rather than you start writing your own terms in there. Because one of the terms I see, home inspection for informational purposes only. Our contract says under miscellaneous, any handwritten or typewritten provisions override all other provisions in your contract. So when you start writing your own contingencies, you might be undoing another part of your contract. So be careful how you start structuring your own addendums, okay? And then the last page, needless to say, signature for the buyer, okay? But before we do that, go back to page 12 there, under other terms, data ratification. Data ratification. Who fills that box out? Who fills the box out, data ratification? Well, whoever gets the last initial to the last change to the contract and can prove that it's been delivered to the other side. Remember in the session we talked about the definition in 31A. It says ratification date, and it says see definitions. So if you go back to 31A of your contract, okay, and it says ratification is when all parties have signed and has been delivered. So if it has an email address in there and you scan and email back to that email address from your seller's house, then you have ratification. But if it has to be delivered to a physical address, until it's delivered there, that box does not get filled out. And that's where we run into some problems, okay? Because the listing agent got the last initial from their seller and they filled the box in. But paragraph 6 said it had to be delivered to 429 Mineral Avenue. And all they did was email it back to the listing agent. Well, we don't have ratification yet in accordance with the definition. So until you can prove it got to 429 Mineral Avenue 3 days later, okay, so I received it 3 days later. I have 10 days for my home inspection. So I'm counting 10 days from then. The listing agent is counting their 10 days from when they filled the box in. We're going to have a disagreement, an understanding, right? So we have to get on the same page as to when that box gets filled out. And if it's filled out improperly, a judge would probably look at the terms of the contract and say, okay, buyer, when did it get to your house? Or seller, listing agent, prove when it got delivered. And then you need the buyer and the seller's signatures and date it, okay? So that, and all buyers and all sellers must do this. Now it says for information purposes only, all the listing broker's name and information, co-op broker's name and information, but Tyler RESPA Disclosure Act requires all this information anyway, so that lenders and other people don't have to be asking for it. Go ahead and fill it out. And that's the end of the basic sales contract. It's a long journey, but we made it. Any questions? Sounds like somebody trying. No?
Yes, I have a question, Larry.
Okay.
If you are an agent and you're listing your property and you have someone who's listed for you, you still need to check that as a seller that you are licensed?
Yes.
Okay.
Okay. So you can't get out of the duties of being an agent just because you hire someone else.
All right.
Okay? And I hire someone else whenever I buy or sell something because I need somebody in between me and the other side.
Yeah.
Yeah, I'd rather pay them a little bit of money and have somebody
Exactly.
running interference for me.
Yeah.
Yeah. Good
Okay.
question.
All right. Thanks.
Anybody else have any questions about anything we discussed or anything else today? Okay, just as a reminder, even if the emails that go out with the flyer only has the course login number, you still need the passcode. It will always be the 723635. So make sure you keep that handy for logging in. I noticed the email yesterday did not have the passcode in it. I'm glad that all of you found me or remembered it. I will be here Monday, and we will be discussing the conventional appraisal form and appraisal contingency notice. So actually be doing it from Daytona Beach. I'm headed back there for a while, but I will be there this Monday. Last Monday, I hope you remembered I wasn't going to be here because I had to teach for the board all day. So next Monday and Wednesday at 11 o'clock. Any questions anybody has about anything else?
Another question, Larry.
Okay.
Can I, as a Fairfax Realty Select agent, can I use any of the houses that listed by the company for advertising without
only with their only with their permission still.
You still have to get the permission.
Yeah.
Okay.
Yeah, unless it's IDX, Internet Data Exchange. It can show up on your website, Internet Data Exchange, but you couldn't advertise it.
I hear. Okay.
Okay, because the seller also has to agree to it.
I see. All right.
Okay.
Okay.
Any other questions?
I have a rental question.
Okay, I'll try to answer it. I don't do
So
much with rentals.
There's a situation where, one of the agent submitted an application, and we didn't change the status of the listing as application received in rental, and they submitted, but after 2 3 days they came back and they said, oh, the priority was to get to other property, and they just came back today, so we are withdrawing our application. In the sense, they don't want to move forward on it. They
Okay.
give security check, 1 month check to Fairfax Realty. So
Uh-huh.
the landlord got upset that they're using us to keep in a, in a side if the other deal doesn't go through, so he
Yeah.
said, basically the thing is that he was saying next time we'll tell them to, if the application is received and application is accepted, then we have a right to keep the security deposit. Can you do that even if the lease is not signed?
Not, no. There's no right to keep the security deposits. Once again, they have to require a release.
You cannot do it until the lease is signed. After the lease is signed, you can keep it, but in
Yeah,
between,
but still, if I would still say there has to be a release signed, using, because we still have some other laws that's, under the rentals that come into effect. So I would say you don't have an automatic right to keep the security deposit of the first month's anything. Okay.
can a landlord
So
make a rule
be
that he will
careful.
accept application only if
No, landlord can't make a rule to override our statute.
okay.
Larry, can I
Now,
ask
they
you?
have 3 days to change the way it appears in Bright, but they can't just automatically keep the deposit. Okay, and that's one you could also submit to Matt over at NVAR. And look, if you don't forget, if you're a member of NVAR, go to the legal hotline and submit legal questions if you have. The attorneys will get back to you within 24 hours and discuss it with you. Okay?
Okay.
Larry, can I ask you? Hello?
Sure. Yes.
On the contract, residential contract 41, other terms. The buyer agent can write down that if suppose I'm submitting any contract for the seller, can I write down that this contract is valid until next day, 24 hour, 48 hours, something like that?
Absolutely.
Okay, thank you.
So, but you want to write that it would become null and void if not accepted by that time period.
No, I will write down 48 hours, such and such date by 5 p.m.
Yes.
That's
If it's
fine.
not accepted by that time, it will be null and void.
Okay, thank you.
Okay.
Thank you.
Yeah.
Hi, Larry. I have a question.
Okay.
After you say something, it just kind of give me some thought. So when you say when you buy your property, you hire someone, right? And then
Yes.
is there a certain percentage you share with them? Or it just, kind of, I know you kind of things?
It depends on what the transaction is going to be. If it's a commercial deal, I have somebody I would go to. Residential, I have somebody I would go to. I'm not looking for advice. I'm looking for somebody that knows how to properly handle the transaction. They're not going to get a whole lot of money. They get a referral fee. I still get the commission. Okay.
Oh, so,
So,
okay, that's interesting. So even the person doing some sort of transaction, they just getting a referral fee.
they'll get a referral fee from me for being the person in between. I'm not looking for them to do a lot of work. That's just like, when I got my divorce, I had an attorney that did what I told them to do. I knew what I was doing. Okay. So,
Okay, got it. Thank
I
you.
look for people. I look for people that, and that was 25 years ago, by the way. It's not like last week or something. So,
Okay, good to know. I mean, I never thought about it, and then it was just you are a realtor and then you are buying yourself, and then I was thinking, why you're hiring someone, you know?
Well, because you're emotionally, so let's say I was selling the house where I raised my kids. You know, there's an emotional attachment there, right? So I need somebody between me and my emotions to remind me that this is a business transaction. It's a house. It was a home when I was buying it and living there. It's nothing but a house now. It's brick, mortar, and sticks and stones or whatever. Get over it. You know, your emotional attachment isn't worth anything to the buyer. So that's the reason I like somebody in between me, slap me around a little bit and remind me. Okay.
Okay, got it.
But I'm only going to pay you so much to slap me around.
Okay, great. Thanks.
Okay.
Thank you.
Okay. If there's no other questions, then I will see everybody on Monday. If you can make it, 11 o'clock. Remember, save that passcode. You're going to need it to get into any sessions in the future. Okay.
Okay.
Thank you.
Thank you, Mr.
for
Larry.
finding me.
Thanks.
So thank you for
Thank
finding
you.
me.
Thank you,
Okay.
Larry.
Oh, and by the way, it is my birthday on Friday. So if anybody wants to drop a gift by, I'll take it.
Will do.
Okay, Larry, okay with you.
Happy birthday in advance. Thank you.
Happy birthday.
I'm kidding. No gifts, but it is my birthday. So
Happy birthday.
yes, I'll be 73 years old. Wow. So
Happy early birthday.
all right.
You're looking
Thank
good.
you.
Okay.
Thank you. Bye-bye.
See you
Bye.
guys.
Thank you and happy birthday.